Staying with us. A group of activists, including senior advocates of Nigeria, at SANS, have called on the newly appointed Chief Justice of Nigeria, Olukayode Ariwoola's successor, Justice Kekere-Ekun, to prioritize judicial reforms. The advocates emphasized the need for urgent reforms to address the lingering issues plaguing the Nigerian judiciary, including delays in justice delivery, corruption, and inadequate funding. They urged Justice Kekere-Ekun to build on her predecessor's effort and take bold steps to restore the integrity and independence of the judiciary, ensure speedy justice delivery, and promote transparency and accountability. The group also highlighted the importance of strengthening the judiciary's institutional capacity, improving judicial appointments, and enhancing the welfare of judicial officers. With the new CJN at the helm, the advocates expressed optimism that the judiciary would experience a significant transformation, leading to improved justice delivery and enhanced public trust. Well, joining us in the studio to have this conversation is Fred Nzako, a lawyer and public affairs analyst. Fred, good morning. Thank you for joining us.
Thank you. Good morning.
Now, let me begin with the President's statement about Justice Kekere-Ekun saying that she is a beacon of hope to young women who aspire to break glass ceiling across sectors and seek to make a meaningful impact on the society. Now, let's begin with your perception of, her emerging. She rose through the ranks to emerge over the years, and she is here now. What you make of she being the new CJN, first of all, before we go to other issues?
Well, my congratulations to her. She really broke the glass ceiling because being the second female Chief Justice of Nigeria in history and the 23rd in the line of Chief Justice of Nigeria, she actually has joined Honourable Justice Alooma Mukhtar to break the glass ceiling. And of course, I agree with the President that it is an encouragement to Nigerian women, to share the young ones to work hard, go to school, hold your heads high, and not be found in the same room where men are corruptly enriching themselves. And some ladies, yes, some have tried to outdo the men in corrupt enrichment, and they have brought opprobrium to the female folk, because God, in His infinite mercy, created women very distinctly. Of course, nature recognizes that women are very distinct and in all ramifications. Forget these modern tendencies of what a man can do, a woman can do better. Yes, there is a quality of humanity, but there is a distinctive place of women in nature. And every woman must be very conscious of that.
Right.
And that is why many Nigerians are excited that once again we have a woman as the CJN at a time when the justice delivery system in Nigeria needs a lot of reforms. A lot. Not just one, not two. Some reforms will need her personal touch as a woman of distinction. Some reforms will need her personal touch as a no-nonsense jurist. Some will also need institutional reforms. Institutional because there are so many institutional structural changes that need to be done so that we'll be able to not only bring justice to the people timelessly, so that all this old cliche of justice denied being justice delayed, justice delayed being justice denied, we should work towards that. Yes, there have been some legislations that try to arrest that. But in practice, there are so many things that we still need to do to ensure that people are given access to justice in due time, so that there will be no such denial on account of delay in justice delivery. And I think we expect something good. But as we go along, we also will tell her where the booby traps are set. Because the mindset of the people is also very important. The perception of the people is also very important. And if there's any such perception that was negative before she ascended into this exalted office of the CJN, she has to try to use this opportunity to correct those impressions so that Nigeria will continue, or rather will revive their trust and confidence in the judicial system.
Great. And you know, it's great that you mentioned that, because she also said that our priority is restoring public confidence. That is an affirmation of, you know, the fact that there may be some challenges within our legal system in the country. But what should be the major areas that she should touch on as soon as possible? Well, they have commended the past CJN, yes, tried what he could, but we still need, you know, to make more effort.
Yeah, the past CJN, just very briefly, he tried his very best. But there was still this public perception on one side of his public life, which the new CJN will try to avoid, and that is nepotism. And in a situation where, sitting as the Chief Justice of Nigeria, his people are always being appointed into judicial offices. Daughter-in-law being appointed a judge, son-in-law being appointed a judge, son being appointed a judge or daughter, and then in-law being appointed auditor of NJC, and then it goes around, because even the president of the Court of Appeal, the daughter was appointed a judge, the Chief Justice of FCT Abuja, the daughter was appointed a judge, the Chief Justice of Federal High Court, daughter was appointed a judge. So in a situation where appointments are more or less, it is not, it doesn't run in a family. It shouldn't run in a family. I mean, it should be based on merit, based on capacity. I'm not saying that all these people don't have the merit and the capacity, but when the impression out there shows more of nepotism than recourse to merit and capacity, because if the son of a poor man cannot get to that point, or will not even be given an opportunity to get to that point, then that means you have to query that standard for which the others were appointed. If they stand, because normally we should expect that such standard will be built on merit and capacity. But this is one aspect of the life of the former CJN, which is crying loudly in the public, which the new CJN should try as much as possible to handle. The other aspect of perception, which will also be, of course, there's no need we running away from such a reality, because on January 3rd, 2020, she sat on the panel that awarded governorship to, I use the word advisedly because that is the public opinion, advisedly to the current governor of Imo State, that made the public to be calling him Supreme Court governor. And the people felt that there was no substantial justice in that judgment. And that was what compelled the Supreme Court to revisit that judgment on the 3rd of March, the same 2020, and still reaffirmed their judgment. I remember that some civil society organizations, of which my humble self was one of them, we gave extensive exposure to the courts on what we felt should be done, hoping that, I mean, the trajectory should be corrected, and then whatever that was wrong should be corrected, because the other party was saying that even their own issues were completely sidelined. And then when the review came, only Justice Sentus Nweze, now of the blessed memory, gave a dissenting judgment and said this was not right, that the way and manner the judgment was arrived at, which, of course, the nitty-gritty is not what I'm talking about now. But the name of Honourable Justice Kekere-Ekun continued to spring up in both cases. And Honourable Justice Sentus Nweze said that this will continue to haunt Nigeria for a very long time, this kind of judgment that was given in Imo State governorship election. And of course, we saw that haunting. Now, why we have to bring that up is for her to know that that public perception is still hanging. I thank God that she now has an opportunity to correct everything. Because if then she was not the Chief Justice of the country, you can say maybe she had a limit to which she can influence things. But now, as the Chief Justice of Nigeria, of course, her confirmation is a fait accompli. She naturally is taken to, she must be confirmed by the Senate. So we are not afraid of whether she will not be confirmed or not. So that is why Mr. President had to even swear her in, because, I mean, we are not talking about issue of confirmation, because even Mr. Fabio, the Vice President, was there and then extolled her virtues. So we are happy that she was appointed, and then we have to let her know that this public perception is hanging. there will be off-cycle elections before the 2027 election, and good enough, she will still be there, God sparing our lives, including her own life. She will still be there in 2027 election when there will be another general election. And what her activities between now and then will, to a very large extent, determine her place of history in Nigeria.
That's the way she can
system.
Correct that.
She has to correct that perception by the action she will take, starting from now that she is now
up until
justice.
then.
Yes.
Interesting. Now, there are senior advocates who have spoken about what she should do. But before that, you mentioned something that there are areas where there are booby traps that she needs to, take caution and that she needs to be told.
Yes.
I need you to expatiate on that, especially the challenges that you see she might confront.
It is the structural challenges. Structural challenges in the sense that Supreme Court of Nigeria, we have only one Supreme Court. And in that Supreme Court, when it is in full complement, it will have 21 justices. 21 justices, and of course you know that unlike the High Court, they don't sit singly. The minimum that Supreme Court will sit is about 5. If it had to do with issue of interpretation of the law, they will sit in full complement of 7. All right? So on what it now means, assuming they are sitting 5-5-5, that means at all times only 4 matters will be treated by the Supreme Court at all times. 5 times 4 is 20, all right? With the CJN making it 21. So what it now means is that the court is overburdened. And that is why some matters will lie in Supreme Court for years unattended to. And it is one of the major, and if you are a litigant and you don't take it to the apex, you continue to feel that you have not exhausted the options provided for you by the Constitution. So, and that is why people try as much as possible to take it to the apex. And in some cases, one of the reasons even why the Supreme Court is overburdened is the fact that lawyers, to become senior advocate, you have to serve some minimum number of matters that you have handled at High Court, Court of Appeal, and Supreme Court. And what it now means is that in a quest to become an SAN, some lawyers even drag their clients to the Supreme Court. Even when the client says, I don't tire, the lawyer will say, no, you have a case. The client may not know. The underlying factor is that he wants to hit that target that will make him to apply for the rank, prestigious rank of the silk.
Right.
And he will now drag the matter to the Supreme Court. And there you continue to have a glut because many matters keep coming there. I will suggest that as a country, there is nothing wrong with diversifying the Supreme Court justice system in Nigeria. There's nothing wrong with having 6 Supreme Courts in the 6 geopolitical zones. There's nothing wrong. Today we have Court of Appeal in virtually all states. We have the division, Lagos, Ibadan, Benin, Ilori, and all these divisions of the Court of Appeal. So the effort by the judiciary is to have Court of Appeal in virtually all states. The other day we had the one in Oka, the one in Owerri, the one in Enugu. So if we can have Court of Appeal in all the states, for example, and FCT, is there anything wrong with having Supreme Court in the 6 geopolitical zones? So that certain matters will not end up in one Supreme Court in Abuja. The wheel of progress grinds slowly. Right. And one of the reasons why it grinds slowly in Nigeria is this structural bottleneck that we have. Somebody is now accused of possibly murder. You expect that that person will struggle to the Supreme Court to free himself, naturally. And then, after Court of Appeal, no date for Supreme Court. It lasts for about 8 years. And by the time Supreme Court hears it, there are some matters that are had after about 10, 12 years in Supreme Court. It is not the making of the justices. It is because of the glut in the system. What is wrong with we having 6 Supreme Courts, and then we have 1 in Abuja? So that all the issues that are arising from the state high courts, because we have, in our laws, we have dichotomy between the state high court and the federal high court. Even though they are courts of coordinate jurisdiction, they are equal in character, equal in capacity, but they handle different matters. One for the federal government, or rather for the federation that has to do with federal laws, one for the state that has to do with state laws. And then at the level of the appellate court, the Court of Appeal, it tappers. Anyone can come, whether from cultural, whether from state, whether from federal, whether from even religious courts, like the Sharia Court of Appeal. They now go to Court of Appeal. But we have enough Court of Appeals in all the states. So that the major problem is, by the time you get to Supreme Court, now you have the glut. And that is where the finality of that judgment can never come on time. In some cases, the litigants die off, and the matter will die off naturally. I will advocate that we have Supreme Court in the 6 geopolitical zones, handling matters that come from the state, and we have the Supreme Court in Abuja, handling matters that that originated from the Federal High Court. It's a big reform. And I thank God that she is 66 today, and God will keep her alive beyond 70 and thereafter. All right? So she has 4 solid years to make a major reform. Now, Mr. President is just 1 year in office and has 3 years. So even if it means sending an executive bill to National Assembly to effect that, it will not receive the challenge of anybody. Every Nigerian will love it because everybody relies on the judiciary as the last hope of not only the common man, but the last hope of our democracy, the last hope of our business enterprises, the last hope of our foreign investors. Because if you cannot get judicial system to handle your matter timeously, as an investor, you will be laid back if you are asked to come and invest in an environment, because there will always be contention, there will always be issues. And the question and the issue is, how much has the judiciary handled that? I want to see this kind of reform, major reform, constitutional reform, but it's not beyond our handling. Right. The next issue that she will be a low-hanging fruit is on the issue of appointment. These are things that she can handle. Issue of appointment. Let the appointment not be on who you know or the family you come from.
I think you mentioned that.
I've mentioned that. Then we now begin to talk about discipline. Discipline is key. Discipline is not only of the judicial officers, but also discipline of the citizens. Why should touts from Kogi State go and be embarrassing Nigerian judiciary in the hallowed compound, the premises of the Court of Appeal? Last week, Friday, the Court of Appeal gave judgment in favor of Usman Ododo. I mean, the Supreme Court gave judgment in favor of Usman Ododo, confirming his governorship. And then, all of a sudden, the talks that filled up the whole chambers started harassing and stoning the opponent that brought the matter to court, Ajaka. Yeah. Murtala Ajaka. In the compound of the court of the Supreme Court. In fact, in the foyer of the Supreme Court. Some were using sachet water, some were throwing all manner of things at him, and he had to hurriedly be taken out. Supreme Court, of all places, oh goodness me. That simply shows that she should not tolerate this kind of shenanigan, this kind of irresponsibility. Because any politician who brings talks to the hallowed chambers of the court must be severely punished. Severely punished. You know, and then Nigerians must know that the Supreme Court is not a playground. It is the apex court of the land. And the building and the appurtenances surrounding the building are all hallowed. Right. And sanctimoniously must be respected.
Absolutely.
There are a lot of issues that she should address, like you have said. But apart from even the structural issues, there are still concerns about the independence of the Nigerian judiciary. I mean, she was sworn in by the executive, subject to confirmation by the Senate. The Senate has different political parties. There are concerns that perhaps there will still be a level of political influence in the majority of the decisions that we make. And are there hopes that for our democracy in Nigeria, we should achieve, true political or true judicial independence of the judiciary without having to, be subject to confirmation by, other arms of the government that are having different political parties?
I agree and accept that justices and judges in Nigeria are under intense pressure by politicians. And that is why it is not everybody that can be made a judge. Not everybody. There are people who are so naturally contented that give them any amount. In fact, they see that local, they see that big sack of money, as a heap of garbage. We look for such people and make them judges. There are people like that. There are people who believe that life is all about touching humanity. And how do you do so? By keeping an upright lifestyle and not by the quantum of money that you have accumulated. There are people like that. And if you now appoint someone on the bench on the basis of merit, character, and integrity, the person will look back and want to give back to the society. But if you appoint someone on the basis of connection and contact and who has submitted the name, the person will look back and will want to always look at the face of the person who appointed him or her, or who influenced the appointment. That is one major aspect of it. So when you talk about independence, in a manner of speaking, there is relative independence in the judicial system by way of the chance to do what is right. The National Judicial Council does the recommendation, and Mr. President cannot appoint outside the recommendation of the National Judicial Council. And not to make sure that such recommendation does not carry a lot of political toga, they follow the seniority in the apex court. They follow the seniority such that if Mr. A is retiring, you will know who will be the next in line. And if that next in line is not competent, of course, that next in line shouldn't have even been appointed to the Supreme Court. Right. And because the feedstock from the Supreme Court is from the Court of Appeal, the feedstock from the Court of Appeal is from the High Court. So you start to catch it young, catch it right from the level of the High Court. Honourable Justice Kekere-Ekun started as a magistrate. If she didn't do well, she wouldn't have been promoted to the High Court and to the Court of Appeal, to the Supreme Court, and now at the apex, at the CJN. So we have to ensure that that feedstock that feeds the appellate court, you make sure that you appoint people based on integrity, based on character and merit, and not based on connection. All right. And as a matter of fact, once that is done, I tell you that we'll begin to get it right in that respect.
Unfortunately, we couldn't touch on some recommendations by some senior advocates in the country because of our time, but so much has been said. You've touched on major issues, and so we must thank you, Fred Nzako, lawyer and public affairs analyst, for your time on the program. Thank you so much.
Thank you.
Right. Finally,